San Mateo County, and this is my second year on the CMFA.
I'll be very brief as I introduced myself previously. My name is Andrew Tufton. I'm a State Bar employee with the Office of Professional Competence.
Hi, I'm Isabel Liu. I'm a staff attorney with the Mandatory Fee Arbitration Program. I'm responsible for enforcing arbitration awards issued by the local bar associations and the state bar. I also serve as the committee liaison for the Committee on Mandatory Fee Arbitration.
Hi, I'm Mimi Lee. I'm State Bar staff, Office of Professional Competence.
I'm Steve Bundy. I'm a member of COPRAC. I have practiced law some. I used to be a professor teaching legal ethics at UC Berkeley.
Hi, I'm Amy Baumsey. I'm the current chair of COPRAC, and I'm a partner at Arnold & Porter in San Francisco, and my practice is primarily professional liability, counseling, and litigation.
Hi, I'm Drew Dilworth. I'm the current advisor to COPRAC, so I'm on my last year here. I'm a litigation partner at Cooper, White & Cooper in San Francisco, and my practice focuses on the law governing lawyers. So I do litigation defense for lawyers as well as risk management counseling and ethics counseling and so forth.
Hello, I'm Stephen Sparta. I'm a psychologist and a public member of the committee, and this is my third year.
Okay, so Andrew asked me to just say a little bit about COPRAC and its mandate. So COPRAC is the standing committee on professional responsibility and conduct, and our mandate is education of the California lawyer community on ethics and the rules of professional responsibility. A large part of what we do is draft and publish ethics opinions. We also, from time to time, are called upon for other duties by the Board of Trustees. For example, during the long period of the Rules Revision Commission, a significant part of what we did was provide comment on new proposed rules. We also do outreach panels. We have a symposium once a year, which I recommend to everyone. It's a fantastic, pretty high-level, day-long conversation about cutting-edge ethics issues. And welcome. This is a very interesting combination.
Let me just give you a brief description of the Mandatory Fee Arbitration Committee. We're actually 40 years old. Actually, the statute is 40 years old. In 1978, the California legislature enacted Business and Professions Code 6200 through 6206, which is the mandatory fee arbitration statute. For a period of time, the Board of, I guess it was Governors, oversaw the program. Then they decided that they wanted to form a committee, and I believe the committee was formed in 1984. And we're actually very multitasking. We generally interface with 35 to 40 local programs. Most of fee arbitration is handled at the local level program. If the local program can't handle the fee arbitration, then the state bar will administer the case. So in connection with that, we actually train arbitrators how to handle a fee arbitration. So a lot of our work is done presenting training programs throughout the state, from all the way from San Diego County up to, say Butte. We present a basic program, which is around 3 hours, and then we've recently instituted an advanced program which trains an arbitrator how to actually write an award. We also prepare arbitration advisories, which I think is the closest function to your committee, where we basically give guidance to arbitrators and program about how to handle certain issues that come up in an arbitration. And these presently reside on the State Bar website. I counted them today. There's 45, and they deal with, various subjects that an arbitrator will encounter. One of the tasks that I think our joint committee will take on is their revision. And usually we revise them if a case comes out, say for instance, the statute of limitations for fee arbitrations. A couple years ago, a Supreme Court case came out, Lee versus Hanley, that sort of changed the landscape on that, so we had to revise that arbitration. If a statute comes out that deals with a change regarding mandatory fee arbitration, we'll revise. So we're also tasked with reviewing cases that are published, how they impact our program. There are minimum standards that apply to fee arbitration, so we make certain that each local program rules comply with those minimum standards. We get a lot of requests to change the fee schedule that local programs charge. That's an example. We have public outreach with Superior Courts. I was on a radio program that was a public outreach to explain what we do. If there's a case that implicates MFA, one case I can recall is the disclosures that an arbitrator has to make, Baxter versus Bach. We thought the Court of Appeal got it wrong. So we put together a letter to the court asking that the opinion be certified. So those are some of the tasks that we presently do, and will sunset in about 6 months. And anybody else on the committee want to chime in and add anything?
I would just add, what I do as presiding arbitrator, there's an enforcement function in the fee arbitration statute. So if a client is awarded a refund of fees and the attorney doesn't pay that after a certain amount of time, they can apply to the State Bar for assistance in enforcing the award. Isabel will normally start that process and will try and convince the attorney to pay. If they claim they can't pay, there's a process they'll go through where we try and work out a payment schedule. If that doesn't work, one of the things I'll do is we can issue sanctions, well, not sanctions, but against them that go directly on the bar dues bill to try and get their attention, to get them to pay the award. If that ultimately doesn't work, then I file actions in State Bar Court to have them enrolled inactive until they pay the award. We also, along with the assistant presiding arbitrators, if there's a request for removal from county bar program to the State Bar, we'll issue opinions on jurisdiction and things of that nature. And the presiding and assistant presiding arbitrator positions are surviving. Those aren't going to terminate in June. So.
I should know this, or I feel like I should know it, whether I should or not. What's the sort of caseload? What are the caseload parameters? How many mandatory fee arbitrations happen around the state? How many go, and how many go to the more contested stages where you end up with the State Bar involved?
Yeah, it varies from year to year. We do keep stats. Isabel, we get that in our program packet when we meet. And ironically, we always try to decide, what are the ups and downs, because we deal with lawyers and money. Sometimes I've speculated it affects the economy. Lawyers, when they're feeling flush, there's less fee disputes, and just the opposite is true. I can't give you actual stats, but one stat that we're really proud of is after a case is in fee arbitration, I believe our stat is 95% of the litigants accept the award and don't request de novo, which I think we're doing our job when we get those kind of results. So hopefully that's answered your question.
I was going to say, it varies from year to year. I mean, on average, statewide, most of them are handled by the local bar programs, but between the local bar programs and the state bar programs, several hundreds. I don't know if we've ever, I want to say there have probably been years where they've gone over 1,000, but it kind of varies, like Lorraine said, with the economy, you get a lot of them. When
That's very helpful. That ballpark is very helpful.
Yeah.
Any other questions, comments? We're just excited to be here and to learn what you all do, and hopefully you can learn what part of the committee's task is going to be part of COPRAC, which I understand is the arbitration advisories.
Could you say a little more about arbitration advisories and how what a typical advisory might look like or sound like?
Or just your
Sort-
process
Sort of,
generally
you
for
know,
working for them.
again, in general, much like COPRAC, because I've, as a legal mal specialist, I've, read y'all opinions. So, it's question presented. What is the law? Sort of
Well,
the IRAC method, discuss and analyze, conclusion. And I think we deal with situations where either the program or an arbitrator is grappling with. And again, anything that you would have in a regular litigation case, statute of limitations, those are the sort of large subjects. Defenses, one aspect of the statute is can legal malpractice, can you obtain an award for damages that deals with legal malpractice? The answer is no, but the award can reduce the value of services. So there's just a myriad of topics, 45 at least, that we've come up with now. We were currently working on a cost and interest advisory that's sort of still in the pipeline. So what costs are recoverable in a fee arbitration, and then can you award pre-award and post-award interest? So those just come off the top of my head.
Yeah, they're more ours. A little bit different, I think, from the COPRAC ones. Our advisories, I would say, are more of procedural bent to them. To arbitrators, these are the kind of issues you're going to face with. This is how you deal. This is how you evaluate a malpractice case. This is what happens if somebody files for bankruptcy. In addition to the arbitration advisories, which are all posted on the State Bar website, we issue program advisories directly to programs. Those aren't public. They don't go on the State Bar website. But those are discrete issues because the programs at the local bar level do the intake, handle the bulk of the cases. So there's, once again, procedural type advisories, how to handle certain things. Once again, if somebody files for bankruptcy or if there's a subpoena for records, things of that nature. So.
Are the advisories, are they generated because you get a question or because the committee decides it's something?
Both.
So,
Mhm.
yeah.
About what percentage is questions?
I think it's more things. I'd say most of it are issues that have come to our attention, either from case law or from arbitrators or programs, raising issues. One of the things we do, in addition to the trainings, we have program administrator roundtables twice a year, one in Northern California, one in Southern California, where we invite the program administrators and the local bar program chairs, and it's just basically kind of a roundtable where we hear what they're dealing with, what issues, what they think they need help with, and that kind of gets things moving up the pipeline to what we think needs an advisory.
And when we train arbitrators, I think we're trying to get uniformity of analysis and decision. So these advisories assist people. When I do training, I always say you don't have to reinvent the wheel. Go on the State Bar website. You're going to find a lot of helpful tips and tools on if you get a certain case that deals with voiding a fee agreement and how to do a reasonable value of services analysis. And so in our trainings, we cite these various advisories, because if you're new to fee arbitration, you don't have to reinvent the wheel. There's a lot of resources, and I think the advisory are one of the best resources to not only educate an arbitrator on, what you have to do when you write an award, but sort of, the path analysis to get to that conclusion. Client owes nothing, lawyer owes client. It's there for them.
Do you have a sense of how those kind of going forward, how those things like those biannual meetings, are those going to continue?
Excellent question.
Yeah, I always say we're in transition. Don't know.
Those decisions, I think, are largely out of our hands now.
Yeah.
Right.
It would, obviously, we would love them to continue because, I've sat as a pro tem judge for about 20 years, and sometimes you're in a vacuum when you serve as a bench officer or arbitrator, and you want guidance. And when you sit in a room where other people have the same issue come up, and you're able to assist them to work through that issue rather than you sitting, in your office having heard a case and trying to grapple. I think that the roundtables, both from the program level, and we do have arbitrators come up, you sort of work out the issue, which I think is very helpful.
Yeah, that's kind of the trainings is also kind of in the flux situation. Up till now, we've always done live trainings. It seems like the push now is going to be more to online trainings. My position, I like the live. I think we can do both. The live ones are good because, I've done them throughout the state, and you get feedback directly from people who are arbitrators. While it's a training, you also learn from them. You see what's going on. It gives a direct chance to interact with them and find out what they're dealing with and answer their questions. So I guess it's yet to be determined how those are going to proceed.
Okay, so I think there's some substantive things that we're supposed to turn to, but I'm not entirely sure what they are. So maybe I can let either Lorraine or Andrew guide us.
Sure, I'm here to defer to the Mandatory Fee Arbitration Committee as well. I'll just state it's my understanding that two of the responsibilities that COPRAC will be taking on is the arbitration advisories, as well as updating the excellent sample written fee agreements that you guys have already developed. And it's also my understanding that you are working on updating the sample written fee agreements with respect to the new rules of professional conduct. And to the extent you have any questions about how those rules should be referenced, I know anyone of the COPRAC committee who's here would be happy to help work through those, as well as if any of the updates to your advisories are causing questions or concerns with respect to how the new rules should be referenced or worked in. We're here to help as well.
So I guess in the written materials for today's joint meeting, we do have the sample form fee agreements, a little bit of history. I think these agreements had not been updated for about 19 years. So our committee took on the Herculean task back in 2015 to completely update them and actually add more forms. So what you see is the work product of a subcommittee. Ken and I were on it. Mark Schreiber, Andrew's partner, and a couple other people worked through all of these. So the actual form agreements, there's hourly, contingent fee, sample optional clauses, joint rep. Those have already been vetted. So when the new rules came out, I think a couple months ago, we actually went through them all to make sure if we had any references to the old rules that they now match up with the new rules. So that's in your program materials. So if you have any questions or comments on those, and obviously we have not started on going through the advisories, but I'm sure we have a lot of references in various advisories which cite to the old rules, and maybe one comes to mind, unconscionability for 200. There's now 13 factors instead of 11, so we use that in the reasonable fee analysis, which is probably our largest advisory. I think it's 20 pages. So that work has got to be done to go back in all those to make sure that the references to the rules and any concept analysis is updated.
So, just to be clear, you're going to update all of the advisories, the previous advisories?
I think they have to, unless we just, another suggestion just popped in my head that we put disclaimers on all of them that say, these contained references to the old rules in November 1st, 2018, the rules have been changed. I mean, that's a way to deal with it too.
Yeah, I don't think there's that many. The reasonable fee one has the sites to 200, the unconscionability factors. We've got one that deals with malpractice and how that factors in. So there's some 3310 and 3300 references in that one. Most of the other ones probably don't have much in the way of the rules of conduct, but I assume that's something, since we now have till June, that we can probably clean that up before we're formally sunsetted. But
so right now, if anybody has looked at this sample, at our last meeting, we actually went through and changed the rule, and if there was any reference to 4200 and the factors, we changed those out. But the rest of the agreements in substance, have not changed. They were fully vetted for, I think, 2 years we worked on this, Ken.
yeah, I think the only one we had to somewhat substantively change is we've got the contingent fee, the non-litigation hourly, the litigation hourly, and then we have a number of optional forms. The optional forms had a flat fee provision. We've had to update that in light of the change on flat fees, so that's in there. In the bodies of the agreements themselves, it was mostly just references to rules that we changed. And we have 2 disclosure forms that we put in the optional forms: a third-party payor disclosure and consent form, and a multiple-party joint representation form.
Well, 3300 is in that, and 3310. So.
Yeah, the 3310. I don't think we referenced the numbers in those. I'll have to go back and look at that. But that's now been broken up into all sorts of different numbers. But I think substantively, it still fits with the new rules now.
So is there any questions or comments from anyone? I don't know procedurally what we do, but I usually sort of move along quickly and ask for a motion to approve as submitted. But I guess we could have comments first.
I have a quick question. I mean, when it strikes me, we're not going back through all of the old COPRAC opinions to update the rules, and it's not clear to me that you necessarily need to do so. That would be, it's up to you. It's obviously a question of, but that doesn't feel to me so critical.
Yeah, and I think how this difference is, if you're an attorney, you're preparing a fee agreement. So you will want your fee agreement that you send out to your client.
I totally agree. I was distinguishing between the advisories and the fee agreement. I thought I heard you suggesting you might be updating the advisories, and that didn't strike me.
Like I said, I think there's only 2, maybe 3 that actually reference the rules.
If it's a small number, obviously that's a whole different question.
Yeah, and that's why I suggest that maybe you just put on a disclaimer at the end that says, the rule has changed. Because some people, some attorneys will not realize until a couple years later
that's very
that we do have new rules.
Yeah.
And every chance that we have to inform and educate, is great. So
I had a couple of questions. I certainly agree with you about the flat fee point, right? And I heard you, I wondered on your third-party payor point, I didn't see that there was, maybe it was the one about, I wasn't sure that there was a clear reference to the rules about third-party payors and the,
Yeah, it comes up on the very first line,
Yeah.
the disclosure and consent third-party payor. Under California rule, it's now 1.8.6 instead of 3310F.
right, but what page is that at, excuse me?
Yeah, 8.
Next to last
Yeah,
page,
next to last page.
Of, right,
Yeah.
I'm trying to find the right page. I may just have missed it completely. Okay. 88, yeah.
I think the only real substantive change when they did the rule was adding the part about how
Oh,
you,
yeah,
you
no,
have
I'm
to do it
sorry, I
now and at
missed
the
this. I
time.
just missed
Yeah.
this. I apologize completely. I was looking at a different language altogether. I apologize. And then, you didn't mention 1.15, but do you think you ought to be talking about how the changes in deposits, the obligation to put fees in trust funds and so forth?
Well, it
the
is,
trust
when you look
fund?
at either the, I believe it's in the hourly lit and
Mhm.
non-lit. In the sample fee agreement, there's always a provision about deposit.
Right, but
And it's
The
in,
way we
it's in
draft,
there.
the way
yeah.
we drafted it when we prepared the form
Mhm.
was, despite what the state of the law was, put it in the client trust account.
Right, our default, and I guess I didn't mention.
That's helpful.
I think the focus of our committee is consumer oriented. So when we draft any type of document, we're always cognizant that there's an attorney and a client. Where some committees are more attorney centric. So when we prepared certain provisions, we always took the more consumer client oriented, which I think is just put into trust.
Yeah, but really your agreement was already in compliance with the new rules.
Yeah,
Correct.
we did that, and we also kind of took like a best practices approach on that. So even though it wasn't required, we had it in the base form that you picked to put it in the client trust account. There's a provision in there when it's earned, so it's clear when you can remove it, things of that nature.
Right.
I have a comment. I just want to say that the arbitration advisories, in addition to giving guidance to fee arbitrators, are incredibly valuable for practicing lawyers and law firms in terms of outlining the basic black letter law of attorney's fees. And I found them invaluable in advising my clients. The forum fee agreements, again, an absolutely invaluable resource when it comes to advising lawyers on how to structure their fee agreements, as well as the general way they operate with fees. So I think what you do fits very comfortably within the portfolio of COPRAC in terms of what we can bring to the process. And I just want to say thank you for all your good work.
Well, you're welcome. We have a lot of members that have been on the committee for a while. In fact, we have people that come back to the committee because I think, as I have said, the work of fee arbitration touches the majority of lawyers that practice in California. And as you pointed out, when we do trainings, not only are we training arbitrators, but I think we're actually, the audience that we have, I think we're improving a lawyer's practice in how to deal with the law of lawyering, which is very expansive and can be overwhelming when you're starting out, or if you've been in practice for a long time.
Well,
Always picking up something new.
I've been doing it for 30 years, and it still feels overwhelming.
Yeah, right. Any other questions or comments about the changes to the sample form fee agreements?
I have a question related to that. Like,
to the new requirement in January related to the confidentiality of mediations in that new section. Is that,
Right.
are you planning on including that in these versions, or how did you?
Actually having a disclosure form that you have to give to your client before you go into mediation?
Well, as part of a fee agreement, if you're going to include a mediation provision under that new rule that's going to go into effect in January, you have to have there's certain disclosure requirements that you have to make. Yeah, that's what I'm referring to.
Pat, from our group, actually sent around the form, so I don't know if you want to comment, Pat, but, we sort of talked about having a standalone form, and then your suggestion, you could just have a paragraph in your fee agreement. In the event that it happens. I mean, not all cases end up in mediation, but at least, I could envision, in the event this case results in a mediation, the following disclosures are made. Bam.
I got an email from one of my colleagues yesterday talking about that, because I believe the rule says it can't be attached to it.
It has to be like one page,
A standalone.
12-point font or higher, and it has
Consumer
to.
friendly. Right.
Yeah, so I mean, you can mention it in your engagement agreement, which isn't a bad idea, but you can't actually use that as the acknowledgement. You have to have a separate freestanding document.
Like I said, we do have the optional clauses in separate forms. The 3310, no longer 3310, but the third-party payor and the joint client ones are separate. We did those as separate standalone forms. So, if we can, in our next meeting, we can talk about doing one on this.
Well, the other thing about it is that the statute, the new statute that's addressing the requirement, it has essentially a form built into the statute.
Right.
It's like
Yeah,
a
I
safe
saw
harbor.
that,
It says if you say this, then you're presumed to comply.
Right.
So I think as a practical matter, what a lot of law firms and lawyers are doing, they're just going to duplicate that exact language on one page and make it compliant. And so on one hand, it's kind of like, well, do you really need the form? But then it strikes me that even if it's right there in the statute, if lawyers don't know about it and they go to the state bar to say, where can I get different types of forms, might not be a bad idea to have
I think
it.
it'd be an excellent addition.
Not a lot of work to do it. I mean, you're probably taking essentially what's in the statute already and just.
Pat
We
sent
found
us
a form
around the
somebody-
standalone, so I think we're ahead of the game.
And the discussion we actually had in the last couple of days was, given the separate document requirement, should you send it in a separate email if you email the retainer agreement to your client to create a separate document?
I've heard those types of arguments too.
This is Kendra. I don't know if you can hear me.
Yeah.
I think Dina's suggestion earlier on that it at least be mentioned in the fee agreement if mediation is going to be a provision put in there. And of course, you wouldn't have to have the form entered into or signed at that point at all, and maybe not even attach it to the fee agreement itself. But I think you at least need to mention it in the initial engagement agreement.
Yeah, I don't know, for people, I was just showing Lorraine one, Hinshaw Culbertson, if you subscribe to their Lawyers newsletter, sent one out yesterday that's got a sample form that I actually thought was pretty good, so.
Yeah.
Yes, I
This is
wrote
probably
that.
your form, Kendra. This is Lorraine Walsh.
That was me.
Oh, it's your form. Well, thank you.
I thought it might be yours.
Yes.
It was a very nice newsletter and form.
Thank you.
So I guess, Andrew, is this something that would need to be agendized for next meeting? Since, at least from our committee's perspective, we don't act and talk about stuff that's not on an agenda.
Yeah, that's the same for us. And because you're still around until June of next year, you have the authority to make these changes and update the form. You don't need, as I see it, COPRAC to do that.
Okay.
I had two suggestions worth considering, and that's the flat fee provision on the optional clauses. I would just recommend looking at 1.15B1 a little more closely. There's additional disclosures that need to be made to the client before the flat fee can be deposited in the lawyer's operating account.
So you're on 3, looking at paragraph 7. Flat
Exactly.
fee. Okay.
Yeah. It shouldn't be too difficult. And the other thing that might be worthwhile is same section, paragraph 10, payment of referral fee. It's largely the same under the new rule 1.5.1, but I noticed that you have nice notes brackets at various sections, and it might be helpful to inform lawyers in such a note setting that they are required to now have the agreement in writing with themselves and the other lawyer as part of the new rule. And that might be something that's new that's helpful to attorneys.
Okay. Other questions, comments?
Yeah, just to the extent that I think with the mediation clause we were talking about, the standalone document, and then whether in the agreement you should refer to the standalone document. But I just also think and maybe this is obvious and you guys have already considered that, but just on that page 7 of the optional clauses where you discuss the mediation clause, and it has, this is an optional clause, and there's some instruction that would be a place, just in case someone's just looking at this to say, by the way, you also have to send this form, this is a requirement, and reference the form there, just.
Right.
Yeah. Okay. I just didn't know if this was different than the context of putting it actually in the agreement, referencing the standalone form, so I just was, to clarify.
We try to make it as user-friendly as possible, because I don't know if you've ever seen some fee agreements that come through in your practice, and they don't change much from what's on the website.
Yeah.
So to the point that the brackets are still there and all that. So
Yeah.
we've had those thoughts. Yeah, and what Ken is just saying is, in light of some really great comments here this afternoon, that I think our committee should look at this at our next meeting, which I believe is February 3rd, and incorporate your comments and maybe bring back, if we have another joint meeting, some additional optional clauses, what we've discussed here today. So we won't be approving anything today. Sound like a plan? Okay.
Were there any questions with respect to arbitration advisories that you guys were working on, or?
Like I said, the
Not
two
yet.
that were in the pipeline before we were informed that we will be sunsetting out were costs and interest, and I think we need to do more work on them.
I think the cost one's done. I think we're just waiting for.
I think both need to be, in rereading them, both need to be worked on a little bit more. That's just my opinion. But those are the two that we had in the pipeline.
And then you, as a committee, you guys will meet to discuss as to whether or not you believe it's necessary to update the prior arbitration advisories, or you've already made that decision?
Yeah, we could do it 2 ways. I mean, your
and you're
comment
going to
was
update
good. Do you need to go back and, change the rules, or just put a disclaimer on it? Because if you cite it, I mean, again, some lawyers still believe that the rules still apply. So there's 2 ways of doing it.
It's not a big task.
But if it's a couple opinions, that's a lot different. I mean, for COPRAC, you might have an opinion that deals with, 6 different rules. And so to go back and redo all of those would be
Right.
not very practical. But if the reality is it's 2 opinions and it's the same rule and it's the central rule that arbitrators use, then maybe that makes sense. Actually, I have one question about the advisories. I think I probably know the answer, but do you guys complete them and approve them and sort of formalize them in the same process that COPRAC does with its opinions?
No, that's when they were talking about sunsetting the committee, I guess that was one of the issues they looked at. Because these were basically internal procedural advisories. We would form them, we have a subcommittee, we vet them at the committee meeting, and we go back until we're all done, kind of similar to what you guys do internally.
Right.
But then it doesn't go to public
Yeah.
comment.
Oh,
It
okay.
doesn't go up the
Okay.
chain. So
Good
I
to
think
know.
the impression I got from the governance task force is they want to do something along that lines moving forward.
Oh,
Yeah.
okay.
And we were just discussing it before we came in. I think public comment, I'm just trying to see where that would fit in to arbitration advisories, because the targeted audience is arbitrators. So while, I'm all out for putting it out in the world, what's the value to it? Um, you know, I guess it wouldn't hurt, but if you're truly wanting to get feedback,
Certainly
I-
a smaller universe of lawyers.
yeah,
then.
exactly. Yeah. Although I'm sure there's someone out there that's just waiting for that arbitration advisory on costs to come out to do their public comment. So, but I thought for some reason that the board of trustees maybe think about minimum rules.
So where the board
Yeah.
gets involved is when the local rule programs have to, under the statute, for a local bar program to be operational and have immunity under the statute, their rules have to comply with the guidelines and minimum standards and the statute. So anytime a local program is proposing changing or updating their rules, that would come to us as a committee. We would then review it, make our recommendations, and from there it would go up to RAD, and then RAD would pass it up, and ultimately the board would approve the rule. That's the one that does really go up
Yeah,
the chain.
but not advisories. Yeah.
Okay.
That's how we differ.
And I think, I don't know, it might be going in-house now, moving forward on the rules, and I think how that process is going to be.
What do you mean by that?
Advisories are going to be
The
done
advisories,
in-house.
I'm not sure. The rules, my understanding
I get it.
is a lot of what our committee did is going to be handled by staff now.
Right.
I think on the advisories and maybe on the fee agreement forms and getting some members on COPRAC, they kind of wanted to have the merger on that. I don't know what the plan is with rules, whether that's something that's going to come through COPRAC or just through just through staff and then up the chain that way.
Yeah, and then a large part of what we do, like I mentioned, was the training. So I could envision that COPRAC would be a very good vehicle to, get some training if you're still in existence. And one of the highlights of me being on the committee is to do trainings throughout the state and meeting new lawyers and recruiting arbitrators. So that might be something that, again, it's out of our hands, but just throwing it out there to the universe that this COPRAC group would be interested in doing.
Yeah, one thing we did discuss at the last meeting is, to the extent FEARB and COPRAC are going to be merged, is I love the ethics symposium, but maybe doing something similar to that on fees. Because one of the things we did as a committee, we put on COPRAC did as well at the annual meeting where we put out, best practices on fees and fee disputes and ethics regarding fees, and we don't really have a vehicle for doing that anymore. So I was thinking something akin to the ethics symposium, but a fee symposium might be a good idea to spend a whole day dealing with those issues.
Yeah, because we usually had 4 or 5 programs at each annual meeting, and I sort of kept stats on who had signed up, and we had very large turnouts, which said to me that there was a need. And then after you do your program, then you had all the lawyers that are lining up to still talk to you. So I thought there was a real need in that area of fee disputes and how you interact with your clients.
There's a huge need for education in confidentiality.
Yeah. Yeah.
Of course, I see it's what Sal.
No, I think we all do if we're in this practice area, but
Anything else for the good of the order?
I think that's it, huh? Great.
All right. Thank you all. It was very nice meeting you.
Yeah, you too. Of course. Yeah, I think that's it. I think we're out a little early. What's that? We are done also.
Wow.
Yeah. Yeah. Well, that's,
Two opinions out in 1 hour, getting out an hour early.
you could draft the conclusion now.
No.
There can't. Like, no.
No, I've
You
got
literally
I've
cannot.
got the sentences in my head, but I need to
No, I was,
take a little time.
yeah, no, absolutely. No,
It's
that
okay.
was
I
good.
feel like the character in the old comedies. Now.